Hello, everybody. My name is Tran, and I'm a PhD student at New Mexico State University. Today, I would like to talk about our paper titled Analyzing GDPR Compliance of Name Data Networking. This is a collaborative work with Reza Tourani from St. Louis University and our collaborators Gaurav Panwar, Satyajayant Misra, and Travis Machacek at NMSU. So let's begin. A growing number of users receive unsolicited ads and feeling like they are being tracked, or even worse, realizing their data stored in an application was used without them being informed and without their consent. A standout example of this is a Facebook Cambridge Analytica data sharing arrangement in 2018, which allowed Cambridge Analytica to harvest millions of Facebook users' personal information for targeted political campaigns. What's more, a growing number of unannounced or delayed data breach notifications, unauthorized processing, and unclear linkability of data for further targeted advertisements are all challenges that need to be dealt with. In order for these privacy violations to be prevented, the GDPR is now in the European law and its regulations strictly enforced. Enacted in May 25, 2018, GDPR aims to protect the internet human rights of European online users by putting them more in control of their data. For users, it means they are aware through consent of exactly and explicitly how their data is processed. For data collectors, it means their systems must comply and be vetted through a data protection officer according to regulations. This most extensive privacy regulation at over 50,000 words applies to anyone who is an EU data collector, collects data of EU citizens, and essentially anyone who collects, records, organizes, stores, or performs any operations on data as internet privacy rights grow greater concerns outside the EU. Similar to the EU, regulations in California, such as the California Consumer Privacy Act, Children's Online Privacy Protection Act, and beginning on November 1st of this year, China's national privacy law will continue to provision a robust framework for online privacy protections. In this presentation, we are pleased to offer a beginning discussion of the GDPR regulation compliance and data protection revolution of the name data networking architecture. The linkability of data is in fact very intertwined. One piece of data about a person can be linked to another revealing aspect of them. For example, a recent study shows that most users are naive to this. They are willing to share their health and shopping data, but not wealth data, when in fact the prior is possible to reveal the latter. Such correlations are largely predicted by machine learning algorithms, allowing businesses to collect critical information from users and using the data against them without their knowledge for advertisements, solicitations, or any manner for which the original purpose of collection was not used. Because the GDPR does not state explicitly what technologies a company must use, what they must do to comply, or levels of security a data collecting organization must comply to, it is often illustrated as vague or hard to interpret for companies looking to assess their systems for compliance. For this reason, many companies who fail in readiness are struck with harsh fines up to 4% of their annual turnover revenue for their precarious systems. Harsh fines can, however, be prevented for prepared systems. When designing a prepared system, we must be wary of what data is logged, how it is stored, how long it is used, where the data is going and where it has reached, and is the user interface for which consent is and what is the user interface for which consent is given, and the constraints given by the user consent, and are the constraints given by the user consent respected, and can it be proved? These questions that must be answered seriously are used to avoid fines when approached by data protection authorities and to prevent being fined. Because GDPR is of concern to all data, legacy systems as well as innovating technologies like name data networking will be applicable to these regulations. In the next slide, we provide a brief overview of the name data networking. Then we provide an analysis of each NDN feature in need of more in-depth design approaches to encourage the creation of a body of future works from fellow researchers to explore each NDN feature to ensure GDPR compliance. In NDN, a data consumer sends an interest packet requesting data, which is backpropagated through the reverse path by another NDN node that carries the data. The data is verified by the signature of the producer, while the requester of the data is not known due to the lack of requester information and granted through backpropagation along the reverse path. These signatures are built based on a schematized trust, which are revealed on the hierarchical naming scheme of NDN. An NDN forwarding node consists of a forwarding interest space and content store where it handles incoming requests and data packets while storing data for more optimal local servicing. Human readable names of interest and data packets, caching, stateful forwarding and of named packets, built-in trust are all NDN features that we will analyze. Each facet of NDN where GDPR applies and in need of analysis are illustrated by the GDPR shields in blue. First, we notice that naming requires protection if it contains personally identifiable information. Next, the stateful forwarding plane should be proved to not be in violation of the terms and conditions. For example, operations on packet names beyond the PIT and FIB operations. Additionally, the lack of consumer identity denies the data producers the right of knowledge to who receives their data. Content store, which must protect the data in case of data breaches. Lastly, the packet's signature is susceptible to lack of anonymity when the content producer wishes not to be identified with the data. Recent initiatives in addressing compliance by retrofitting old systems and assessing new technologies have covered the topics of IoT networks, software-defined networking APIs for tractability of data, and blockchain-based storage systems and access controls, which we refer to in our paper. Based on extensive review of the case management system on all GDPR fines, these are some of the fines that we found relevant to NDN and direct the audience to the paper for more cases. First, ETID 118 pertains to NDN nodes that fail to separate personal data that may be susceptible to breach and thus require extra security and tractability requirements. In ETID 226, the fine resulted as a result of using non-human readable static identifiers that denoted and exposed personal health information in a school database. This brings forth the concern for naming schemes in the NDN's in-network intelligence that may result in the same exposures of its data owner's data when processing named data. The lack of consumer identity in NDN results in servicing data without knowing exactly where it is going. In preventing a similar case to ETID 34, it is relevant for NDN to design a scalable data tracking mechanism. Lastly, ETID 422 is similar to ETID 34, where a failure to track and access data for erasure may also result in a fine due to lack of tractability. To this end, we urge that NDN's in-network intelligence and largely cache-based architecture calls for much research efforts to ensure GDPR compliance. In our paper, we divide the relevant NDN features across the two ends of the relationship between data subject on the left and data controllers on the right. Data subjects are the providers of personal information, any identifiable person. Their rights related to the use of NDN are granted by the following articles on the left. Data controllers are the collectors of personally identifiable information, and their responsibilities are related to the use of NDN are granted by the following articles on the right. These are the questions we must ask in the NDN naming scheme as it relates to these articles to be explained. Article 5 suggests that these names are processed only for specified purposes. Hence the question, will the names be processed outside core NDN forwarding operations? Articles 6 and 9 require naming to be processed only on consent if they expose any revealing information. So does the name contain sensitive or identifying information? Lastly, if the name contains any identifier, can the data packet be monitored such that it complies with Article 29 and 35, which informs personal data collectors to transfer the risk of sensitive name signature and data packets to only authorized data processors? Next, we have caching. NDN as a cache-based architecture will be heavily influenced by the GDPR requirements. We identified 12 articles pertaining to the responsibilities of data controllers and 4 articles pertaining to data subjects and their rights. The relevance in NDN may be summarized by asking the following questions while we direct the audience to read our paper for further details. Can the data be located upon request? Processing is only insertion and deletion of cache, and what is the proof? Or is there more processing being performed? Will the data be transferred? And lastly, is there a possibility that personally identifiable information will be cached? Any processing beyond what is legal in the context of NDN stateful forwarding plane are those beyond the PIT and FIB operations as we defined in our paper. Without express permission from the data subject, processing beyond the PIT and FIB operations can be categorized as unlawful. Consent must therefore be predetermined before an NDN network considers using edge routers for enforcing access control on personal data at the strategy layer, for example. Next, lack of consumer identity in the consumer interest packets poses a question of how sensitive producers know who accesses or who accessed their data, which in turn poses the question of how will records of data trail be kept if needed. Since each data packet is signed by the producer, each data packet is linked to the owner of that data. NDN applications thus require trust relations that anonymize identifiable information where appropriate. To address these issues, NDN must ask whether users can be identified or anonymized over their certificates and whether such certificates can be evicted. Our paper assesses the logging and encryption overheads over latency and CPU utilization that addresses the fundamental compliance requirements on a per-node basis. We ran the producer application on a desktop, Ubuntu 18.04 with 4 GHz single-core CPU and 8 GB of RAM, and the consumer application on a MacBook Pro running OS X Catalina with 1.4 GHz quad-core CPU with 8 GB of RAM. In our experiments, we use NDN CXX library version 0.70. There are other aspects left open to research to assess, such as the design of a scalable logging mechanism for network-wide deployment, name obfuscation solutions for naming privacy, and the compliance for GDPR. In the first set of experiments, we've measured the total content download time under 3 logging levels: no logging, logging cache operations, and extensive NFD logging for 0, 25, and 50% cache hit ratios. As shown on the figure to the left, logging all operations slightly increased the total content download time across all experiments. We also noticed that the content retrieval time decreases as the cache hit ratio increases, which is in part due to the fact that the producer needs to generate and sign a smaller number of data packets in scenarios with higher cache hit ratios. In summary, we note that the latency cost of logging in the current NFD version is negligible. One can also observe that enabling extensive NFD logging has increased the CPU utilization to 8%, up from 4% where there is no logging. This increase in CPU utilization is also consistent across all cache hit rates. To evaluate the overhead of providing cached personal data protection, we ran a set of experiments by extending NFD with data encryption using AES 128 in CBC mode, where data is encrypted before caching and decrypted per cache hit. We assessed the packet retrieval latency for the cached data at 25 and 50% cache hit rates, with no logging and no encryption. No logging but use of encryption, logging of cache operations with content not encrypted, and logging of cache operations with content encrypted, as seen on the figure to the left. Encrypting and decrypting the protected cache data introduced negligible latency overhead across the board. We also noticed that using bigger cache sizes resulted in lower retrieval latency. This is because the producer now has to generate and sign a smaller number of data packets. Overall, we argue that protecting cache data for GDPR compliance imposes an acceptable overhead where we get similar corresponding results when measuring CPU utilization, illustrated on the figure to the right. We conclude with the following topics for discussion and insights. First, the issue of consumer identification. As in Article 15, the data subjects have the right to know the recipient of their personal data. However, NDN interest packets do not carry consumers' information. Next, for timely request processing, GDPR's Articles 16 to 18 and 21 are among the most prominent articles which grant data subjects rights to request rectification and erasure of data. So, can tractability and real-time compliance be developed in NDN? For network monitoring, a distributed auditing framework requires the design of a holistic and unified auditing framework to enable data subjects to provide their consent and data controllers to provide the relevant records in a secure, immutable, and comprehensible manner. Lastly, though in this work we investigated NDN for GDPR compliance with a focus on the networking infrastructure rather than the applications and services at the application layer, we argue that GDPR compliance of the application layer services is a different dimension and requires per application assessment, with our 2 cents that encryption and tunneling is not enough. Thank you for listening, and let's follow with a Q&A and discussion in the breakout room. Have a good day.